Hello, and welcome to today's 2026 webinar series. Thank you for taking the time out of your busy schedule to join us. Before we begin, I'd like to note that this webinar is being recorded and all presentation materials will be posted on our website. If you would like to ask a question, please use the Q&A feature, and if time allows, our speaker will jump into that at the end. I'd now like to introduce you to today's speaker, Matthew Schoonover with Schoonover and Moriarty, who will be speaking to you today about debriefings and bid protests. Thank you.
Hey everyone, good afternoon. Thanks so much for joining today to talk about everybody's favorite topic when it comes to government procurement, right? A little bit of litigation, bid protests, and essentially the importance of how debriefings and bid protests shape the procurement system in each individual procurement. So I'm glad that everybody could join today to have this discussion. My name is Matthew Schoonover. I am the managing member of Schoonover and Moriarty. We are an Olathe, Kansas-based law firm that specializes in representing federal government contractors from a lot of the fun things that come from being a small business federal contractor. And as part of that, we do represent folks in throughout the bid protest process. And so certainly I know it's something that nobody necessarily looks forward to, but is unfortunately sometimes a necessary part of the acquisition process. And so I wanted to take a little bit of time today to discuss some of the key considerations when it comes to deciding whether to file a bid protest or not. Although we will be talking about legal topics today, and although I am an attorney, I would certainly encourage you, please don't take today's presentation to be legal advice. If you have specific questions about any of the topics that we'll discuss today, or really anything else related to government contracting, I encourage you to reach out to Government Contracts Counsel, be it me or one of the other many capable government contracts counsel that is out there to best understand the situation and how your business might proceed. So with that quick overview of what we're going to talk about today, we only have just a few minutes here for our lunchtime presentation. So we'll start off by talking about debriefings. Debriefings can oftentimes trigger the clock for understanding when a bid protest might need to be filed. So we'll talk about what debriefings are, when they're required and when they are not. As well as some of the important considerations and tips to keep in mind when you are going through the debriefing process. And then from that, we'll transition into really the discussion about bid protests. We'll go over some of the major considerations when it comes to filing a bid protest, including information that needs to be provided, where those bid protests might be filed and when they should be filed, as well as some of the more common arguments that we see when it comes to bid protests. And of course, we'll also end with a discussion about why your company may choose to file a bid protest, and if it does, again, some tips for going through that process. Before we break into it too much, though, I did want to give a quick plug to our blog. Everybody loves a good legal blog, and here at the firm, we have one called govconbrief.com, and on GovConBrief, we talk about a lot of these topics as they relate to small business government contractors. So if you haven't checked out GovConBrief yet, I would certainly encourage you to do so and make it one of your regular GovCon resources. So let's break in right away to talking about debriefings. And you know, what is a debriefing? Essentially, the debriefing is the summary of the agency's evaluation findings and determinations. You know, the agency, after it makes an evaluation, needs to generally provide companies with a rationale for an explanation of why it evaluated their proposal the way that it did. And these generally come in two flavors. The first is a pre-award debriefing where maybe the agency has made a competitive down select determination, or it has established a competitive range, and it is providing an explanation to offerors about why they did not make it to that competitive range. A post-award debriefing, on the other hand, is where the agency has made an award determination. It is decided that one proposal stands out above the rest under the stated evaluation criteria, and it's decided to make that proposal a contract award. And in that case, the post-award debriefing will include some information relating to that evaluation determination. I will note, though, that a debriefing differs from what is called a brief explanation of award. Debriefing is a term of art under government contracts, where sometimes it is used as commonplace, just as shorthand to say, can you tell us why you made the evaluation decision that you did? But under the FAR, a debriefing is a very specific thing. It is something that may be required or may not be required. And if a debriefing is not required, then generally offerors are instead entitled to a brief explanation of award. And as its name implies, that brief explanation is oftentimes very brief. You don't get the same kind of information that you might get through a debriefing. Rather, the brief explanation provides, in most cases, really bare bones information about why the agency evaluated your proposal the way that it did. I mentioned the pre-award debriefing, how these come in usually when the agency is going to develop a competitive range and the offeror that is receiving the debriefing was not considered among the most highly rated proposals and is therefore being excluded from further competition. In the case of a pre-award debriefing, the agency does need to provide certain identification, or excuse me, certain information to the debriefed offeror. And that information generally relates to the agency's determination of whether there were any significant elements, positive or negative, in the proposal, and a summary for why the agency decided to eliminate the company from competition. More often than not, that summary is just, in my experience, a restatement of fact. That is, the agency says something like your offer, your bid was not chosen for further consideration because it was not among the most highly rated. A lot of times there is not a great deal of insight into any comparative aspect as to why you were not considered among the most highly rated. And in fact, agencies cannot discuss certain information relating to the evaluation of other proposals. They cannot disclose in the context of a pre-award debriefing the number or identity of any of the other bidders, nor can they discuss any of the content of those other bidders' proposals. So the information that you receive as part of a pre-award debriefing is going to be very limited to really only information that is relating to the agency's evaluation of your proposal. As part of the debriefing process, agencies should respond to offeror questions about whether and how applicable procurement regulations and proposal requirements were followed. Again, sometimes agencies don't necessarily allow as much of a robust questioning period as they might, but as part of the debriefing, you do have that opportunity to ask questions. The information that you're going to get as part of a post-award debriefing, or that you should get as part of a post-award debriefing, is really of greater quality and quantity than what you'll get as part of a pre-award debriefing. Again, in the post-award context, the agency has made an evaluation and award determination. So in this case, there may be more of a comparative aspect of proposals, but as part of the the post-award debriefing, the agency needs to discuss significant weaknesses or deficiencies that it found in your proposal, the overall cost or price of the award, and the technical rating of the awarded proposal. If it created a ranking, it needs to give you the ranking and provide a summary of why it made the award determination it did. even though it's supposed to provide you that summary, an agency is not and cannot provide you any type of point by point comparison of proposals. That is, you won't get any analysis well, you proposed 15 FTE and the awardee proposed 17, and so we liked what the awardee gave us more. You won't get that level of information about the awardee's proposal or any other bidder's proposal in there as well. So keep in mind that notwithstanding the fact that you'll receive more information as part of a post-award debriefing, the agency is again prohibited from discussing certain aspects of awardee proposals. Here again, if you have questions about the evaluation, the agency under a post-award debriefing is supposed to answer those questions. Debriefings, as I mentioned at the outset, are not always required, though. They are only required under certain procurements and in certain context. Under negotiated procurements under FAR Part 15, as well as for task order awards that exceed $7.5 million, agencies are required to provide you with a debriefing if you timely request one. Also, DoD now has procedures or requirements in place that in context of task orders or contracts valued at $10 million or more, debriefings are required, enhanced debriefings are required under DoD's regulations. But that means basically every other procurement, a debriefing is not required. Instead, if it's a GSA schedule, task order under a GSA schedule, FAR Part 8, a commercial item, simplified acquisition, or a sealed bid, you're instead only entitled to a brief explanation of award in that context. I mentioned that debriefings are required in certain contexts if they are timely requested. And the FAR has very specific timeliness rules where you need to ask for a debriefing within 3 calendar days of receiving the notice of award or evaluation determination. So once the agency tells you, hey, you've either not been selected for the competitive range or your proposal has not been chosen as the most successful, as the successful offeror, that's what triggers your 3 calendar day deadline to request a debriefing. And keep in mind that it is 3 calendar days. So if the agency tells you on a Friday, you need to have the request in on Monday. That request is pretty simple. I tell folks, just respond back to the contracting officer's email and say, thank you, I request a debriefing. There's no magic language, nothing required. You don't have to send a letter. You don't have to be super formal. You just have to say something along the lines of, I want a debriefing, and that will cover it. Now, debriefing at the Department of Defense, over the last few years, there have been rules that have gone into place to provide more of a right to a debriefing. And in certain contexts, DoD may have to provide you, as part of the debriefing, a redacted copy of the agency's source selection decision. That is the decision where the agency actually goes through and does more of a comparative analysis of proposals and provides a rationale for its award. Now, it doesn't it will still provide that in redacted form, so you'll still be limited on the information that you get, but you do tend to get more information under the enhanced debriefing. As part of that process, too, the agency has to allow you the opportunity to ask questions as part of the debriefing process. Those questions have to be received within 2 business days of the receipt of your debriefing. And importantly, your protest clock doesn't start running until the agency actually responds to those to those questions. So debriefings are going to be a crucial part of the evaluation process because it's really going to tell you why the agency evaluated your proposal in the manner that it did. That's going to inform a few things. First of all, and most notably, hopefully it's going to inform your proposal preparation efforts for the next opportunity. That is, if the agency comes out and tells you that they viewed something as a weakness, you'll know in future proposals, hey, I really need to button this up. Similarly, if they tell you that they viewed something as a strength, you'll know I did this really well, and maybe I should enhance this or continue to focus on this for the next opportunity. So it's going to provide you more information about how to be successful under these procurements in the future. But debriefings also help make sure that there's a fair evaluation. You get to question the contracting officer, you get to question the agency. And if you don't like their answers, you can use the debriefing to inform whether and to file a bid protest. And if so, what bid protest arguments that you're going to make. So I tell people when they're going through the debriefing, or after to make the most out of their debriefing, you want to make sure that you immediately request a debriefing and do so in writing. And I will say, in the context of a pre-award exclusion where the agency has made a competitive range determination, sometimes agencies may give you the opportunity to delay your debriefing until an award is actually made. I caution people against that because that may have negative impacts of protest timeliness. And so I certainly encourage folks to ask for a debriefing right away, and if given the opportunity, to choose a debriefing that takes place immediately. If you have an option, I generally think that written debriefings are best because you're better able to understand what the agency is saying. If the agency offers an oral debriefing, that's fine. I would just make sure that you have somebody there whose job it is to take notes so that you're remembering everything. I also think it's important not to go into the debriefing flat-footed. That is, it's oftentimes months, if not years, from the point where you submit a proposal until when the award is actually made, and then when the debriefing will occur. So I tell people, refresh yourself, understand, recall what the solicitation was, and review what your proposal was, so that you know where things stand, and you can better inform the discussion with the agency at that point. Ask questions of the agency, not just questions that are geared towards understanding what your bid protest arguments are, but pointed questions that you can better understand how you can improve your competitiveness under future procurements. No matter what, I also say that it's important to maintain a professional and non-combative tone. Obviously, emotions can be high. Company just invested a lot of time and a lot of money in winning a bid only to lose it. And now you've got to hear from the agency about what it thinks that you did wrong. And so I tell people, don't be defensive. Come at it, open-minded with the idea of understanding how to improve in the future. And then from that, actually implement the lessons learned. A debriefing doesn't do anything if you just tuck it in a drawer and never look at it again. Next proposal that you have, you want to make sure that you're implementing those lessons and that you're doing all that you can to improve your proposal. That general brief discussion of debriefings now segues into our discussion of bid protests, because whether and when a debriefing is requested is going to inform when and how you want to file a potential bid protest. So a bid protest, if you've never been through one, congratulations, they're not as bad as they seem. But essentially, a bid protest is a formal challenge to an agency's procurement decision. And like with the debriefing, they come in really two flavors. There's a pre-bid protest where you're challenging the solicitation at some level. You don't think the solicitation is clear or fair or something along those lines, and you want the agency to change the solicitation in some way. That's a pre-bid protest. But once the deadline for proposals passes, once you submit your bid and the deadline passes, the time for arguing about the solicitation's terms is over. You can no longer challenge the solicitation terms. Instead, at that point, you'd be left with a post-award protest where you're actually challenging the agency's evaluation and an award determination under those solicitation terms. You can file a bid protest in any of three venues. You can file them with the agency itself. You can file it with the Government Accountability Office, or you can go to the Court of Federal Claims. And each one has its own benefits and pitfalls to them. But first, let's talk about when you're going to file your bid protest. And here's where it matters whether a debriefing was required and timely requested. First, for a pre-bid protest, again, you have to file those before you submit your proposal. Otherwise, after that point, you can no longer challenge the agency's solicitation terms. But a post-award protest has to be filed by no later than 10 days from the date you knew or should have known of the evaluation infirmity, or if a debriefing is required, 10 days from the when your debriefing concluded. So you want to make sure first that you know whether a debriefing is required under your solicitation. If it is, make sure that you timely request the debriefing. If you do that, then your protest will not be due until 10 days from when the debriefing concludes. If you file it within 5 days, however, you may be entitled to stay performance of the awarded contract. And that's very helpful, especially in the case of where you're looking for leverage, or even if you are an incumbent bidder. If a debriefing is not required, or if it was not timely requested, then you have to file your protest within 10 days of the date you knew or should have known of the basis of protest. So when you file your protest is going to be largely dependent on whether a debriefing was required. Now, once you decide to file a protest, you need to meet certain requirements. Of course, you have to have standing. You have to be a bidder that was economically harmed by the award determination. You have to make sure that there's jurisdiction. Depending on where you go, GAO doesn't have jurisdiction to consider certain issues. SBA is going to consider size issues. The Court of Federal Claims has limited jurisdiction in the case of task order procurements, and so there are going to be jurisdictional considerations to determine where you should actually file your protest. You want to make sure that you're raising an appropriate factual and legal basis of protest. And this requirement, it sounds simple, but it is under more and more scrutiny, particularly at GAO. That is, there's this perception that GAO protests are run amok and are overwhelming the procurement system. A perception, by the way, that I think is belied by the data. But nonetheless, Congress has now mandated that GAO implement a heightened pleading standard that says something along the lines of the protester has to show through evidence and through argument that the agency, a sufficient factual and legal basis to understand that, the agency violated the solicitation or procurement regulation. That's always been the standard, but there is kind of more of a heightened awareness of it at GAO. You also have to show that you were prejudiced by whatever evaluation error that you complain of. If at the end of the day, the agency commits an error, but that error didn't actually cause you any harm, there's no reason to file a protest. And so if you weren't prejudiced from the error that you're alleging, you have not submitted a sufficient protest. I mentioned there are 3 different places you may file a protest. Here, the agency, you file those with the contracting officer, and the contracting officer generally issues a decision within 35 days. That's a soft deadline. They can extend it, but that's really what it is. You tell the contracting officer, hey, I think you goofed up with this. They go back, take a look at it, issue a written decision. GAO protests are the intermediate step, if depending on how you look at it, where you file those protests with the Government Accountability Office, and the agency is going to respond to that protest. They're going to provide relevant documents to you as part of the protest process, or to your attorney, I should say. You're going to get the opportunity to respond to and rebut the agency's arguments before GAO issues its decision. And that decision has to come within, under the regulations, within 100 days of the date you file your protest. And that includes any supplemental or new arguments you make as you learn about them throughout the protest process. Keep in mind that you may be entitled, if you go to the Government Accountability Office, to an automatic stay of performance depending on when you file your protest. And so that is sometimes a motivation for people to go to GAO. GAO, at the end of the day, though, is an arm of Congress. And so under our separation of powers, GAO can't actually order any executive agency to do anything. Rather, GAO's decisions are recommendations to the agency. Most of the time, the agencies follow those recommendations. Sometimes, however, they don't. But keep in mind that even if you win in a GAO protest, there is a chance that the agency may not follow what it is GAO asks them or recommends that they do. You can also go to the Court of Federal Claims in Washington, D.C., and the Court of Federal Claims decides protests through a procedure as what's known as judgment on the administrative record, where a protester files its complaint, which is its protest, and then within a certain amount of time, the agency produces to the parties and to the court the administrative record, the complete evaluation file for that particular procurement. The administrative record tends to be more robust than the documents you get at GAO. And from those, that's where the parties will brief the issues. There's oftentimes oral argument on a protest, and then the court issues its decision. Now, the protester has to show an entitlement to injunctive relief under the four injunction factors, and there is no time period set for resolution. But there is a growing consensus or growing impression, I should say, among bid protest attorneys that the Court of Federal Claims may afford a more effective relief than what GAO does, if only because you're getting, in theory, more documents and more of an opportunity to be heard through a hearing. I think when we talk about what are some of the common bid protest arguments or the successful bid protest arguments, those are where you can point to objective factors, perhaps that the agency didn't consider or deviated from in its evaluation procedures. These often point to unreasonable technical or price evaluations. If the agency applies a different evaluation scheme or doesn't apply the scheme that was set forth in the solicitation, if there was some level of inequality in the evaluation, such as through unequal discussions or an unequal assessment of strength and weaknesses between them, or any other type of violation of procurement law. The unsuccessful protests are those that tend to just disagree. I think I did a better job than what the agency gave me credit for. Or I think the agency was biased against me. Those arguments tend to not go anywhere when it comes to bid protests. So instead, try and frame your arguments to be more objective. Now, why file a bid protest? I think it's important to maintain the integrity of the procurement system and ensure that the agency actually appropriately evaluated your proposal. And sometimes the goal is obviously that at the end of the day, maybe through a corrective action or a reevaluation, you would earn the contract award. So there certainly is an incentive to file a bid protest. But there's not just an incentive as a disappointed offeror. If you are the successful offeror, you have the right to participate in the protest process as an intervener. And I encourage any contractor who has received an award that has been protested to intervene in that protest and help defend the award determination. Doesn't mean it'll always be successful. Sometimes agencies take corrective action because that's what they decide they need to do. But you stand a better chance of helping the agency defend the evaluation if you're actually in the game. And so if you do have a right as an awardee to intervene. So finally, to conclude here, we're just about at 2:30. So I tell folks that if you're considering a bid protest, you need to make sure that you act fast. Bid protest deadlines are very quick, as a matter of just a few days. And if you don't timely raise an argument, you can waive that argument or your right to file a protest. And if you're a protest awardee or an awardee, make sure you intervene in the protest. Understand what happens to the award while the protest is pending. Has the agency agreed to a stay, or is this a consideration? If you're an incumbent contractor and you think that it's close, you may be more inclined to protest if it means that you might get to stay on the job. Now, there's no guarantee that that's the case, and certainly you should never raise, an improper protest argument. just for the means of staying on the job. But understanding what happens to the award of the contract during the protest is a key consideration. Know the issues and know the process for where you are filing your protest. Again, and with the debriefing, I say maintain a professional and non-combative tone. The goal at the end of the day is to perform work for the agency, to partner with the agency. And that's it becomes more difficult if protests take on a personal tone. And so whenever certainly we represent government contractors in a protest, we always want to make sure that we're focusing on the perceived errors in the evaluation process and never on the individual evaluators or their motivations. And so you want to make sure that you're being professional in raising the arguments. And of course, implement lessons learned. At the end of the day, you're going to get a protest decision from GAO or from the agency or from the Court of Federal Claims that says why the agency agreed or why the arbiter agreed with you or why they didn't. And at the end of the day, if GAO comes out and says, hey, I don't think this was warranted a strength for these reasons, or the proposal didn't actually discuss this in detail, actually implement those lessons learned as well and make sure that you're incorporating those into future procurements. So with that, that's debriefings and bid protests in a nutshell. I am certainly happy to answer any questions that anybody may have about debriefings or bid protests. And I see that there are a couple in there. Somebody asks, can you define when you should have known when you had a potential bid protest argument? Again, the timeline requirements for a GAO protester are 10 days from the date you knew or should have known of the protest, or within 10 days from the date the debriefing is received. Whether you should have known of a protest argument generally depends on the amount of information that you have. And it's very tricky to know, well, should I have known this? Sometimes that answer is yes, just by the mere fact of, hey, this company is the awardee. Maybe you know that that company has no past performance or has been debarred or is not eligible for one reason or another. Just by getting their name, that might trigger to you that the evaluation was improper. But it might be through the debriefing process that you learn that information, or it might be through the agency report or administrative record that you first learn that information. And those timeliness rules apply at that point. And again, competent and qualified bid protest counsel can certainly help you out with that when it comes to specific evaluation findings. Another question is there a scenario when an agency is not required to provide you an award notice? If an award notice isn't received and a new contract is initiated, what are your rights? My general answer is no. If you bid under a procurement, the agency needs to tell you of the award. Now, how the agency tells you of that award may differ, may depend on the circumstances. A lot of times the agency is going to send you by email an award notice. Sometimes it may just post an award notice to sam.gov or GSA eBuy. And so keeping afresh of those systems and understanding where they are is going to help you know whether or not they provide you with proper notice. Sometimes you can be determined to have constructive notice if something is posted to sam.gov, by the way. Sam.gov is considered the government-wide point of entry. So if the agency posts something to sam.gov, it is considered to provide constructive notice to everybody on the day that it posts that. And so you want to make sure that you're checking these. But if agency doesn't post something or doesn't notify you, that happens. And once you find out about that, that's when you need to start, communicating with the agency and say, hey, I just learned of this award today. I request a debriefing. And start that process and go through it. And again, it can muck things up a little bit, but it has happened in the past. Final question is, as an awardee or incumbent for contract award, what are the government responsibilities to you? What if those are violated or not adhered to? And that's a great question. And it gives rise to really the difference in representation. When the government defends against a bid protest, it's not defending your award. as an awardee. It's defending its evaluation. That's a crucial distinction because as an awardee, I think that's when you need to come in and say, no, 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 we think this award was proper for these reasons. But generally, if you're an awardee or an incumbent contractor and there's a protest that's been filed, the agency's going to tell you about that. Sometimes it's going to tell you to stop work or to stop your transition towards the incumbent contract. And of course, you want to follow those written instructions from the contracting officer. But they should provide you notice of the protest being filed. And when they do that, I encourage you to ask for as much information as they can. If a redacted copy of the protest has been filed, ask the contracting officer to provide it for you. Or if there's a GAO docket number or a Court of Federal Claims docket number, ask them to provide you with that information. And so then you can start to go on online and see what information you can find about this. See if they'll disclose the identity of the protester, all of that type of stuff. But really their obligation is to notify you and then to tell you whether to stop work and then to defend their evaluation, not necessarily to defend your award, but to defend your evaluation. So that's a great question and why I certainly believe it's appropriate for awardees to intervene in a bid protest if their award is challenged. So with that, I know we're a couple of minutes past, but I want to thank everybody for attending today. My contact information is on the screen. Please feel free to reach out to me with any questions or concerns about debriefings or bid protests. Otherwise, it's been a pleasure speaking with everybody today, and I hope you have a great rest of the week.
Awesome. Thank you so much. And thank you for everybody who joined us today. As a reminder, these materials will be posted on our website. And if you need any other additional information, please do not hesitate to reach out to us at events at and remember, we have our new name now, too. So it's going to be events at nsbgca.org. Thank you so much. Bye.
Thank you all.